If you've got a 401k, you know that fees, even tiny-looking ones, can take a massive bite out of your savings over the long haul. But what happens if you start to suspect those fees are just way too high? Well, a huge Supreme Court case just changed the entire playbook, and it all boils down to one simple but incredibly important question. You see, for years, the answer to that question was, frankly, a mess. It created this giant roadblock for employees. But a major Supreme Court decision just cleared the air. And to really get why, we have to first look at the law that's supposed to be protecting all of us. Okay, so to understand why this court case is such a total game changer, we need to talk about this powerful, decades-old law that's basically the official watchdog for your retirement savings. It's called ERISA, and it was passed way back in 1974. Its main job is to set the rules for plan managers, like your employer, to make sure they're acting in your best interest. Think of it as the official rulebook for how your retirement plan has to be run. Now, deep inside that rulebook, there's this one little section, and on the surface it looks pretty simple, right? But oh boy, it ended up creating a massive legal headache. Let's break it down. And here is the legal puzzle that started this whole thing. On one hand, ERISA has this big red stop sign. It says a plan is flat out prohibited from paying a service provider it has a close relationship with. But right next to that, there's this giant go if clause. It says that same transaction is totally fine if the services are necessary and the fees are reasonable. This clash between what's banned and what's allowed is the very heart of this entire legal fight. All right, so this whole legal gray area, it finally got put under the microscope in a huge lawsuit filed by a group of employees against Cornell University. And this case perfectly shows the problem regular employees were up against. So here's the story. A bunch of Cornell employees sued the university. They claimed the fees in their retirement plans were just way too high. But here's the thing. Their case got tossed out by a lower court. And the reason it got tossed out, well, that's the whole ballgame right there. The court basically said to the employees, look, you have to prove the fees were unreasonable before you can even start your lawsuit. That's a huge catch-22. How are you supposed to prove that without seeing the university's internal contracts and documents, which you can only get after you file a lawsuit? And you can see the problem here, right? That ruling set up an almost impossible hurdle. How could any employee possibly know all the nitty-gritty details of these complex deals to prove they were unreasonable from the get-go? It essentially slammed the courthouse doors shut for most people. But the employees didn't give up. They appealed, and the case climbed all the way to the Supreme Court. And let me tell you, the justices saw things very, very differently. And their answer was about as loud and clear as you can get. The justices voted 9-0 to overturn the lower court's decision. I mean, a unanimous vote like that is a huge deal. It's the court basically shouting from the rooftops that the old way of doing things was wrong. And the whole thing came down to these two little words that change everything: affirmative defenses. Seriously, understanding what this means is the key to seeing why this ruling is such a big deal. Let me break that down. Imagine someone sues you for trespassing on their property. An affirmative defense is you saying, whoa, hold on, yeah, I was on your land, but you invited me. See, it's not the other person's job to prove you weren't invited. It becomes your job to prove that you were. The burden of proof flips over to you, the defendant. And this is where you see the massive shift. Before this ruling, it was like the employee had to start the race a lap down, needing to prove the fees were unreasonable. Now, the burden of proof is squarely on the employer. They are the ones who have to step up and prove that the fees they charged were both necessary and reasonable. This is a fundamental power shift for American workers.
Okay, so we've waded through all the legal jargon. But what does this change in the burden of proof actually mean for you and your 401k in the real world?
Well, it means the entire power dynamic has flipped. It is now so much easier to launch a legal challenge over high fees because the initial burden isn't on you anymore. Instead, the fiduciaries, those are the people legally required to act in your best interest, they're the ones who have to open up their books and justify their costs. And the hope, the real goal here, is that this pressure will lead to way more accountability and maybe, just maybe, lower fees for everybody. But wait a second, there's always another side to the story, right? If it's this much easier to sue, what's stopping a flood of bogus lawsuits from people just hoping to force a quick settlement? Turns out, this was a concern inside the court itself. Yeah, Justice Alito basically said, hey, I'm worried this is going to cause some real problems. He pointed out that once a lawsuit gets past that first motion to dismiss, the legal costs can explode. And a lot of companies might just pay to make a weak lawsuit go away because it's cheaper than fighting it.
But the majority of the court pretty much said, we've thought of that. They pointed out that judges already have a whole toolkit to stop people from abusing the system. They can limit the expensive evidence-gathering part of a lawsuit to keep costs in check. And hey, if a lawyer brings a truly ridiculous case, a judge can slap them with sanctions. These are all meant to be safeguards to weed out the meritless claims.
So here's the bottom line. The courthouse door is now wide open for employees who think their retirement plans are getting eaten alive by crazy fees. But, and this is a big but, judges are still there to act as the gatekeepers. It's not a free-for-all. They have the power to throw out cases that just don't have any merit. So in the end, this whole landmark decision leaves us with one huge, lingering question. Is this new power really going to protect employees' nest eggs by forcing companies to do the right thing? Or did it just open up a new gold rush for lawyers? I guess only time and a lot of future court cases will tell.